Ladies and gentlemen, it's time for our third panel discussion. One of the goals of this project is to present recommendations addressed to lawmakers at EU and national levels. How can we make justice systems more efficient? The economy study has developed, as we heard, new indicators, and how can they serve to open up EU justice policy instruments, in particular the EU justice scoreboards. Participants of this panel will be once again Mr. Christian Helmenstein, Berenika Wünschovà, she is Secretary General of the Czech Chamber of Notaries, Bojan Podgoršek, he is President of the Slovenian Chamber of Notaries, Katerina Svickova, she is from the Directorate General Justice of the EU Commission, and Juan-Fernando Armengot from the Ministry of Justice of Spain. He's a member of CEPEJ. The CEPEJ evaluates judicial systems, and he can be seen right here because he's on video. On the other ones, please grab your seats. Mr. Podgoršek, I will start with you due to the reason that you have to leave early. This whole project is designed to trigger change at EU and member states levels, and in Slovenia, as we heard today, such legislation change might happen on succession processes and procedures. Please tell us about it.
Thank you very much that I can start with this panel discussion, because really we are in a hurry. But as Slovenia was a lot of times mentioned today, because Slovenia in the field of competence in succession matters is, like we heard, black sheep of the family of hexagonal countries. We are often said that also with discussions with our Ministry of Justice, with our courts and so on, and notariat in Republic of Slovenia exists 27 years. In that 27 years, we tried to achieve that goal, that we got some competencies in that succession field. We tried, I think, 3 or 4 times till now, and as you know, we were not successful so far. Mm-hmm. But I think something changes. Something have changed in that field, and with the great help of this project, Juvili, Justice Without Litigation, with it is also our Minister of Justice, very familiar, and also our President of Supreme Court, as we have opportunity to see a few months ago in the conference in Ljubljana. Our Minister of Justice were presented there, and also Supreme Court President expressed the statistical data about successions in Slovenia, and he said that 40 judges in Slovenia at that time are dealing with succession cases. In 3% of all cases, there is dispute between parties involved. And as we see and as we heard today about economical statistics and economical data, he is aware that taking that burden from Slovenian courts will make our law system more efficient. But both of them, I mean, Minister of Justice and President of Supreme Court, stated also one reservation. It is a very, very sensible reservation that we have to make public discussion about that topic, that we have to be sure that the solution will bring benefits to our population, and I'm sure that will be the case in that matter, because now we have better basis than before. The big opposition for our proposals so far was our attorneys. But I think we have something very because we started to make the draft proposal for changing of our succession law, which is from 1976, like court commissioners in Austria. It's the same time, but it hasn't been significantly changed from that time. So it's opportunity to change our succession law to give to the notaries the competence in that field, but be very cautious and take care of that we will also ensure that notaries will be covered with term the court, as we are familiar and as we heard today. And we have to respect also the practice, the case practice from European Court of Justice, especially I don't know EE case from Lithuania, and that for our proposal which we are making now is that moment in examined by Slovenian, by Ljubljana professors of law in Ljubljana faculty, and I hope our product, together product, which is based on the Juvili project, will be more successful than in the last.
Are you optimistic that in the end it will result in a similar system like in Austria or Hungary? Perhaps that the court has the final decision and the rest is done by the...
Our proposal is
Notary.
a little different than Austrian case, because we want to take that workload from the courts 100%.
Totally, okay.
Only in dispute cases when the parties involved will challenge the notary decision. Only in that case the court will make his function, which is core business of courts. And I think succession matters are core business for notaries.
Yeah. In U.S. movies, the judge sometimes say, "You're free to go."
Yeah.
But as
No
long as you want to
objections.
stay, it's great.
Okay, I'll stay another 10-15 minutes.
As long as it's possible for you. Thank you. Mrs. Wünschovà, you were chair of the working group for the collecting the data for the economic study that we just heard. What could and what should be done with all the data that you gathered?
Well, I mean, I have the impression that everything possible has been said, but of course, as Professor Helmenstein said, maybe the main focus should be to further develop the justice scoreboard, because without that, without comparison of the data, we cannot see what can be improved. But in my humble opinion, and I think also it might be Stefan Matik's idea, we could maybe build on this data to create another study maybe, or in the non-contentious area of law, and the involvement of notaries in it.
Yeah, you just mentioned the European Justice Scoreboard, which is perfect to ask you. Tell us, tell us a little bit, how is it used as an instrument to make justice more efficient, and how does it contribute to the rule of law and to change?
Thank you.
There is your microphone, yeah. You don't have to switch it on its own.
Thank you very much. Yes, so probably the EU Justice Scoreboard is well known to the audience here. It is a tool which presents a yearly overview of indicators on efficiency, quality, and independence of justice systems of the member states of the European Union. It has been around since 2013, so this year we published at the 10th edition, which already also allows us to gauge developments, trends, present some conclusions also on this. So the main vehicle of how it is helpful to improve the efficiency is indeed providing information in a very clear and in a comparative perspective via a range of indicators. So one cannot just look at one indicator and say, this is it. The justice systems of the member states are complex, and hence we have also been adding the indicators to look at. The member states receive this information. The national authorities then can work with it. We know that it is very well received in the ministries of justice of the member states, by the judiciary of the member states. So, and they then work with this information. We have also regular exchanges with our contact persons for national justice systems, which is a group composed of representatives of ministries of justice and judiciary of the member states, where they help us, support us in developing the scoreboard. And Juan-Fernando is also a very honored member of an active member of the group. So they then help to exchange good practices, tips. And the second avenue of how it contributes to the enhancing of efficiency is because the scoreboard is linked to other EU initiatives, like the European semester, like the Resilience and Recovery Facility now, and the linked resilience and recovery plans of the member states, or also, of course, the rule of law toolbox. And there, the scoreboard provides basically data, information, which then feeds a deeper qualitative analysis, including, of course, other sources that go into it, which then lead, for example, in the European semester to assessments that might, in case there is an issue with efficiency, to country-specific recommendations, as has been, for example, the case of Italy, which has an issue with efficiency in non-litigious cases, for example. And that has, in the subsequent Resilience Recovery Facility and plan, been also included and turned into a milestone, which will be monitored based on the CEPEJ data on efficiency, which is also published in the scoreboard. So there are, to sum it up, there are several ways, of course, how it can contribute, and I have tried to illustrate them.
Mr. Armengot, can you hear us? You have been mentioned just seconds ago. You worked as an advisor for the project. Do you see possibilities that the CEPEJ considers non-contentious procedures more strongly in its evaluations?
Well, yes, thank you very much. Congratulations for the project, and thank you for the opportunity to give my personal opinion. Well, yes, in fact, the European Commission for the Efficiency of Justice, that is also a source for the Justice Scoreboard, already studied notaries in its questionnaire for the national correspondence, particularly in the section 9, and they ask some points about notaries in every one of the 46 countries of the Council of Europe. Particularly, they ask every 2 years about the status and number of notaries, about the access conditions to the profession, about the type or the model of appointment, about the activities that the notaries carry out, for example, particularly about if they, in every country, carry out non-contentious procedures, which areas of the law they perform, what kind of specialized technology they use, and if they use electronic registers, how it is the training of notaries, and which kind of authority they have. So the CEPEJ, in fact, already studied the notaries among the professionals that are involved in the legal system. I have seen that particularly the economic group have done a very, in my opinion, very interesting and very relevant aspect, a very relevant question. They have studied the two principal indicators of efficiency, clearance rate and disposition time, in the activities of notaries in the hexagonal group of countries of the project. I think that this is very, very interesting. I am more familiarized to the investigation of these indicators in courts, but it is, in my opinion, a very relevant experience to measure these indicators also in the notarial offices. Disposition time and clearance rate, as you know, are the principal indicators of the efficiency in courts, and I found very important, very interesting to measure them also, of course, in non-contentious cases that are conducted by notaries. This is something that the Economica study has made, and I congratulate them for this experience. Having said that this has been done, so it's possible to do it, there are other possible indicators that can be also measured, or we can follow. Questions about digitalization. I would like to comment that has been very interesting, the presentations of this morning of Mr. Raúl Radoy and this afternoon Ms. Verena Nodeger. That has been very, very important, this kind of experiences in international connection and in digitalization. About, for example, accessibility, particularly for vulnerable groups. In this aspect, I have found interesting the experience of or the comment of the Professor Christian Helmenstein about the distribution of notarial offices among the population of the countries. So, well, yes, the European Commission for the Efficiency of Justice is measuring some points of the notaries. For the moment, the CEPEJ is not measuring the indicators of efficiency. This is something new in this project, that the project has contributed to the measuring of the legal systems. And we can also even comment the possibility to measure these aspects that even in fact has been measured for the project of accessibility or digitalization, state of play of digitalization, etc. This is what I think that is possible for the moment, I think.
Yeah. Mr. Helmenstein, your study just has been praised by Mr. Armengot. Let's talk about the indicators that he mentioned. Are they a kind of invitation to the European Union to better consider non-contentious procedures? What is your take on that?
I think, first of all, I would like to share the praise then with everybody who contributed to the study. And really, many, many institutions and persons did so and were really eager to get something going. I think I can build directly on the penultimate speaker. Namely, you mentioned the issue of complexity. Our legal systems are highly complex. Of course, they are. But given that they are highly complex, we should strive to reduce complexity to maximum extent possible. And reducing complexity means to operate with clear definitions. That's why we highly appreciate the work from our colleagues from the legal profession, that they proposed a clear-cut definition of what a court is. So what we need first and foremost is, if we want to engage in quantitative analysis in the futures, and if they should be evidence-based, then we need clear definitions. Otherwise, everything starts with a kind of vagueness, and this vagueness will feed through till the end of the analysis. And I think this is not acceptable. That's really the reason why I would like to strongly recommend that we should agree upon definitions first and foremost. And then the second aspect here is, thank you very much, Juan-Fernando, for the cooperation of CEPEJ here, that we build on your excellent work, and maybe we can enlarge the database a little bit, add in new indicators, especially differentiate specific thematic areas to some degree. And what is most important from our point of view, associate institutional responsibilities. Yeah? If you don't associate responsibilities, then there will be nobody responsible for change. Yeah? So it's important to associate responsibilities. And then finally, but not to be excessively long, of course, a lot of activity is necessary on improving the individual indicators. You have alluded to that. Yeah? You have a lot of experience in doing so. Let me just give you one example of a kind of vagueness which we have to get rid of. Namely, there's a statistical overlap in each and every case when cases go from the first instance to the second instance. Yeah? And we cannot differentiate this precisely in a statistically correct manner, how long it takes then to resolve a case, yeah? Simply because it went to the second instance. Yeah? And such technicalities have to be addressed as well. So my proposal would be, let's say, identify those indicators that are already solid enough, robust enough, in order to build on them to conduct efficiency and effectiveness analysis, maybe even cost-benefit analysis. And let's establish a working group that adds in new indicators and deals with those indicators where there is some vagueness left.
Mrs. Svickova, can you elaborate a little bit? How can the results of this project, for example, the indicators, be useful for the further development of the scoreboard?
I think the conversation indeed has been leading to this question, or it flows quite naturally from what we have been hearing so far, and from the results of this project, to which I would like to also sincerely congratulate to all involved. So yes, the results are definitely interesting. Importantly, also, they are promising for the further evolution of the scoreboard, of the tool, which is an evolving tool. That's important to say. We have started somewhere completely else. If you saw the scoreboard from 2013 and now, there has been a long path of development, and we keep developing it. So we listen to stakeholders in, for example, an annual. Every year we publish a consultation of the roadmap, which is now called Call for Evidence for the EU Justice Scoreboard, where we invite stakeholders to inform us where we need to focus more attention, suggest indicators, and so on. And this call will, for example, be published in the next days, about which I will inform colleagues. So it is evolving based on stakeholder input, based on policies of DG Justice or European Commission, based on suggestions from our contact persons, and also based on other experience that we get. We also improve the indicators. So again, maybe building up on Professor Helmenstein point about reducing the complexity. One way is indeed definitions. Another way is, for example, defining scenarios for collection of data. So this is something we have had good experience with in complex areas, where we define a scenario, like, for example, a succession scenario, and collect precise data. And it's important because while the study focused on 6 member states, the European EU Justice Scoreboard looks at 27 member states. So with various legal traditions, different roles of notaries. So a possible step could be working with CEPEJ, working with the notaries, to maybe indeed develop definitions, develop a scenario which would be broad and applicable enough that data could be collected, and then indeed it is open for the path would be open with sufficient quality of data, sufficient let's say coverage of the data to adding it into the scoreboard, which already indirectly also looks at non-litigious justice. For example, we have been regularly publishing an indicator on voluntary dispute ADR procedures and so on. So there is no reason why not to enhance this angle.
I would give Mr. Helmenstein the opportunity to once again promote his case. What are the main advantages of when new tasks are transferred from the court to notaries to reduce?
Okay, I think this is complementary, and I
Yeah,
share what you said. Yeah, scenarios are extremely helpful tool. Let me point out something I noticed from the previous discussions, not only from this panel, but also from the previous panels. I think today we heard several times that the transfer of competences may be conducive to reduce the workload of courts. Yeah? Definitely, that is a strong argument in favor of such transfers of tasks to notaries acting as court commissioners. But I'm not quite sure whether this argument is truly exhaustive. From my point of view, there would even be a stronger argument, an even better argument than this one, namely, from an economist's point of view, the issue is how to avoid inefficiencies. And the major cause of inefficiencies is if an originally non-contentious case turns contentious, or if a potentially non-contentious case turns contentious. Yeah? Because that prompts enormously large follow-on costs for society, for the legal system, including the workload of courts. Yeah? From my point of view, there is a second dimension here. It's not just relieving the courts, but it's reducing the risk that exactly this kind of turn happens from potentially non-contentious cases into contentious cases. And if we can contribute to preventing this situation by involving notaries, then we have gained a lot in terms of efficiency. Yeah? So now there are, of course, a lot of sub-issues that could be addressed. Yeah? Namely, we can minimize interface losses. I pointed out that in Austria we have a hybrid system, yeah? That both sides are involved, court and notaries. Yeah? So probably there are interface losses. And in Austria, we need a kind of physical transfer of records. Of course, in an area, in an era of digitalization, this appears a little bit old-fashioned. Yeah? So we should really utilize the potential from digitalization along the lines what we have heard before. Then we should permit that notaries or courts, notaries better positioned, that they edit a case from the very beginning to the very end. In case that it doesn't turn contentious, of course. If it's non-contentious, why not to edit it from the very beginning to the end? So minimize interface losses, all these sub-aspects. But my most important point is it's not just reducing the workload, but minimizing the risk that a non-contentious case turns contentious.
Mr. Helmenstein, you just talked about my... Oh, you want to say something?
I just wanted to add that danger to turn the non-contentious case to contentious, it is one benefit which is when notary is dealing with that matters, because the notaries we are obliged to give to the customers, to the clients, advices of substantial law, which is not the case when the court is dealing with that matters. The court is obliged to give to the clients, to the parties involved, procedural advices. The notary is obliged to give substantial advices. And this is one very important point. Thank you for all involved. Before I go for this research, we will have to ask for a few more copies to transfer to our lawmakers.
It should be possible. Thank you, Mr. Podgoršek. Mr. Helmenstein just mentioned my home country, Austria. Let's talk about your home country, the Czech Republic. And are there any possible improvements in the Czech Republic by expanding the court commissioners' activities there?
I'm not sure whether it's necessary has to be the expanding the court commissioner function of notaries, but we see a trend of delegating state powers on notaries, that sort of unburdening of the justice system. We have a great example in our country since 2015, which are the direct entries of notaries in the public registers. So meaning that notaries can establish a company, for instance, just they write all the documents and then they themselves made the direct entry into the register. And this is something that has been working extremely well. And 1/3 of all the proceedings regarding public registers is done by notaries. So that is one thing that I think maybe for other countries could be interesting. And of course, another very hot topic, if I may say so, discussed right now in the Czech Republic is divorces, non-contentious divorces before notaries. Because this was one of the policy statement of the new government, to try to unburden the justice system, make it more efficient, make it more accessible for citizens, all the services, and non-contentious proceedings are clearly the way to go. So this is now what we are discussing, the possibility to have non-contentious divorces before notaries.
Mr. Helmenstein, maybe where do you see the most advantages when more tasks are transferred to notaries? Is it succession cases? Is it divorce? Is it registers?
Yes, I think we should start with succession cases. I think that is proven. And all the other fields that were mentioned by my colleagues from the legal profession before, I think are possible candidates. I wouldn't have a preference here. Maybe would not want to start with the most complex cases to begin with.
One question that we haven't dealt with, economic study, of course, that brings to mind the potential for new jobs when tasks are transferred to notaries. Can you elaborate about that a little bit?
That's a fascinating question, of course. So what is economics all about? From my point of view, economics is about finding rational solutions to phenomena of scarcity. How to overcome scarcity, how to improve happiness, how to maximize utility. That is what is economics all about. And now you were asking for the number of jobs created through this kind of transfer. Maybe net effect will be zero, or maybe the net effect will even be negative. I would not be sad about that at all, for the simple reason that I think one of the major scarcity-related challenges we are focusing and facing is demographic aging. So we are going to face an enormous shortage of labor, not an abundance of people able and willing to work, but a shortage of people. So an abundance of jobs, not a scarcity of jobs. And then the question is, how can we enhance labor productivity in order to maintain the level of service, the quality of service? I think that will be the challenge of the decades to come. Just to give you one figure, in Germany, over the next 12 years, 12 million people will retire. The cohort to take over has a size of 7 million people. That is, they have a lack of 5 million people in Germany within the next 5 years. In Austria, it will be 540,000 on top of that. So we'll have millions of jobs for whom we do not find anybody anymore to perform these tasks. And that's why we are talking about enhancing efficiency, using digital technologies in order to enhance labor productivity. So from my point of view, the best scheme we could engage in is the one which enhances labor productivity to the maximum.
Okay. The last thing you mentioned was a recommendation. I would give the word once again to Mr. Armengot. What are your recommendations so that non-contentious proceedings are taken into more consideration by the Council of Europe?
Well, I think that there is something that has been very well done for the legal working group, that has been the identification of the cases. The types of cases has been very well described technically and very perfectly identified. I think that this can be perhaps the starting point, the first step. With this identification, for example, or with adding perhaps any other cases if there are in Europe, I don't know. One first step can be simply to ask the countries in which countries the notaries have competence for every type of cases, succession cases, marriage cases, divorce, etc. So first, to know the map of the European Union or the Council of Europe, the map of Europe to compare, to identify in which countries the notaries have more competencies or competencies in particular cases, and which is the impact in the legal system or in the efficiency of the judicial system, understood as a general system, not only courts. This could be the starting point. After that, of course, measuring the efficiency indicators can be interesting, and this can be the start of the starting point for progressing after that in the line of better measuring the non-contentious justice in Europe, I think.
You were taking notes. Did you want to comment on, or was it just notes for you?
Yes, thank you. They were notes for me.
Okay.
I have noted, no, but it's also,
Okay.
I would like to definitely support Juan-Fernando about mapping of competencies of notaries in the EU. That could be indeed, one of the next very logical steps. But we might still reflect on what other questions, or how do we also go from there to generate the data that we would all be interested in.
The next logical step is to close this panel. Thank you for the participants. Thank you. Well, that was our third and our last panel.